Welcome to the Leadership Blend. I'm co-host Simone Price. We are here today without Ricardo. We're going to have an awesome conversation with the candidate who was running for office. One of our favorite things to do on the show, as you know, is to bring current and local and relevant news to people and to break things down, make them conversational, make them fun, and also help you get to know people who are going to make very important decisions for us here in the near future. So we have an awesome guest with us today. I'm going to allow her to introduce herself and the office that she is running for.
I am Karen Scott Greene, and I'm currently running for Gwinnett Superior Court Judge, Division 8.
Okay, beautiful. So Karen Scott Greene, Karen, you said is okay?
Karen is okay.
Wonderful. Can you tell us a little bit about Gwinnett, what this means for you in terms of running for this office for Gwinnett County and why you chose this office?
So I chose this office because I currently work in juvenile and special education law. And so I started seeing a lot of my young clients moving over to the adult system before they were adults. And so when they move over to the adult system, they don't have the same level of services that they have available to them, rehabilitative services that are available to them that's in juvenile court. They don't have that available in superior court. And so I wanted to see change. And so one of the reasons why I'm running is to be that change that I want to see.
So to take that back, how did you end up working with juveniles and how did you end up representing them? So how did you get into law and how did you end up working with this population?
So I started working with this population back in the late 90s as a baby lawyer. And I got out of it. And then around 2017, I was looking for what brought me the most joy in the practice of law. And I went back and I thought about the different areas that I've practiced, because I've practiced in a variety of areas of law. And what I found the most fulfilling was my work in juvenile court and my work with young people. And so I went back into that arena and started doing I was already doing special education law because I have a son who learns differently. And so I became his advocate, and becoming his advocate, I started doing it for other families. And so in practicing in juvenile law, in the juvenile courts, I work as a guardian ad litem, and sometimes I also represent the parents. But I found myself advocating for my youthful clients also at school when they would have disciplinary hearings or when they needed have an IEP meeting. And so I just incorporated that into a part of my practice.
Oh, wow. So let me ask you even before a little bit more framing. When you say that you worked in lots of different types of law, did you have a specific plan coming out of law school? What drove you to law school? And was the plan to work in a certain lane? Did you plan on being a corporate lawyer? Or did you plan on being a juvenile lawyer?
No, I actually planned on doing real estate development.
Oh, okay.
So I went to law school and then graduated in 94, came up to Georgia, took the bar exam, and then I started at a master's program at Georgia Tech.
Oh, wow.
So I was barred and pursuing a master's in city planning in the land development track, and so with the environmental component. And when I left from there, I worked on my own for a little bit, and then I went to work at Clark Atlanta University at the Southern Centers for Studies in Public Policy.
Wow.
And I was I was an assistant director over the environmental policy programs. And then we had a contract. That contract ended after 2 years. And then I worked for the DeKalb County Law Department, where my client was planning, zoning, public works. And so I was doing some of that land development work on the other side for the county. And when I left from there, I went to work for a real estate law firm, did that for a few years, and then met my fellow, and we decided that we were going to create a family, and I wanted to slow down a little bit, and I wanted to be available for my kids. And so I opened up my own practice, and in my own practice, I did real estate, I did bankruptcy, some criminal law, juvenile law,
Wow.
and that's so in doing that. And family law as well. And so I often say that I dealt with clients in some of the most difficult and challenging times in their lives. Dealing with bankruptcy when folks are losing their home and they're calling you at the 11th hour to help them save their homes. Dealing with, when loved ones become incarcerated and, mamas are calling you to help get their child out of jail.
Mm-hmm.
You know, so, and then in juvenile court, when families have been separated, children have been removed from the home, I either will help the parent, or sometimes I'll be the attorney for the child. So I've dealt with folks when they've had some difficult and challenging times. So I bring that with me when I'm going to sit on the bench, and I understand what it's like being on the other side, and counseling and consulting those clients when they've had challenging situations.
Yeah, I was going to say, a lot of these situations I think are definitely very, very painful to deal with. And you're that right hand that they need to call. So let me ask you, have you run for another office before? Is this your first time running for an office?
First time.
Why not prosecutor, or the quote unquote most powerful actor in the criminal legal system, as we continue to hear? Why a judge?
So I think our current district attorney in Gwinnett County is doing a wonderful job. And so there was no need there.
We don't hear that very much on the show when it comes to candidates.
Well, it's true. What I've seen happen is she's implemented some programs, and this is not an endorsement. I've just seen
I hear you.
I've seen her
but
implement.
It's very thoughtful to hear you say.
I've seen her implement some programs that the community really was calling for. And so, and it's some of the work that I've done with organizations that are involved in the Stopping the School to Prison pipeline, that are involved in criminal justice reform. And so she's making some strides to implement things like pretrial diversion programs, and also doing like first offender programs that are different than what's been done before, where you have to pay and you have monthly supervision fees. So those are some of the things that we talk about in criminal justice reform, and she's implementing some of those things. You know, criminal justice reform in the last 2 years, like after George Floyd, has kind of gotten a really bad name, because people, when you start talking criminal justice reform, there's a segment of the country that believes that we just want to open up the doors to jails and let everybody out. That's not what criminal justice reform is about. Criminal justice reform is about having diversion programs. So if someone is coming before you and has a substance abuse problem, instead of putting them in jail, let's get them treatment. And while they're getting treatment, they can also be working, they can be productive, you know, and they're still in society, you know. And so those are some of the things that is part of criminal justice reform. No one wants violent offenders to be on the street. No one. So if it's a violent offender, someone who's committed what we call one of the 7 deadlies, or someone who's a repeat offender, a frequent flyer at the jail, we don't want those people on the street. So that's not what criminal justice reform is about. It's about let's doing something different, because we know that mass incarceration does not deter crime.
Right. No, it absolutely doesn't. I think this is a good time too to kind of segue to what a Superior Court judge can do, and maybe a little bit more broadly, like the court's role.
Okay.
In this bigger picture, because you're talking about a lot of services and a lot of other needs that are so important for a lot of people. And I'm sure the reason a lot of people come before the court in some cases is because of the lack of some of those services. But what could you do in your capacity as a judge? And maybe you could talk a little bit more about like what a Superior Court judge does for people who don't understand. Okay.
So a Superior Court judge, so we have there's 4 types of judges. There's a recorders in Gwinnett County. There's recorders court judges that mainly hear traffic offenses and also any violations of a county ordinance. There's a magistrate judge who will hear certain types of civil cases under a certain dollar threshold, and also could sit to hear what we call like first appearance cases. And then you have your state court judges who will hear misdemeanor cases. Misdemeanors are anything that's punishable by less than a year. And they also hear civil cases. So Superior Court judges will hear civil cases. They exclusively have jurisdiction over felony cases and over family law cases. If you have any kind of a constitutional issue, that comes before any issue regarding the Georgia state constitution, that comes before the Superior Court judge. And it's also a court of equity. Equity would be if you have a dispute with your neighbor about your boundary lines and you need your boundary lines to be determined by a court. That comes to Superior Court. Anything involving real estate, with the exception of like landlord-tenant issues, that goes to Superior Court as well, exclusively.
So would you define it as like the highest local court?
It is the highest local court. Yes, correct.
So one of the questions I think I got from Ricardo last time I had this conversation was how many judges there are and why, and how that's determined, and like basically what that looks like. One of the questions he had was, should people interpret it as something like a team of people that all split up cases? Is it more like, I think you mentioned like a league, almost like a superior, like the Supreme Court? Like he was trying to kind of understand, I think, how judges work together, if judges work together, and what that process looks like. I know has a lot to do with population size, because there aren't as many judges in some of the smaller counties.
That's correct. And so that's determined by our state legislature. So the number of judges that a county has is going to be dependent upon its size. So in Gwinnett, there are 11 Superior Court judges. The 11th division was just added in 2020. So that's why it's important to know. That's why it's important to return the census so that we can.
Yes, people. Yeah. Yes, I endorse the census. That's a very hard plug.
That's why it's important to return that census so that we can get more judges, and our population is growing. So we have 11 Superior Court judges in Gwinnett, and cases, and so they're considered to be divisions. So like I'm running in Division 8. Cases are assigned blindly, and so they're just assigned.
I don't know if everybody knows that.
Yeah, they're assigned blindly unless a judge has had those particular litigants in front of them before. For instance, if a judge has heard a divorce, if there's any other issues like a modification or anything to do with visitation or custody, that comes back to that. Those cases come back to that judge. But any other new case, it's assigned randomly. So it has nothing to do, just because it has a division number doesn't mean anything. It's just how the case is assigned to those judges.
Gotcha.
So, and currently for 2022, there are 5 judges that are up for re-election, and 3 of those seats are contested. That hardly ever happens. So there are 3 incumbents who have contested races.
I wonder why this could be the case. I think one of the things that you were mentioning with DA Austin Gatson, who we did have on the show a couple of years ago, I think one of the things that we were interested in at that time was just seeing the increase in excitement for the general public around races that are not just the presidential election. That's one of the most frustrating things for us, and then we have a lot of conversations about this, is people understanding that there's always an election. There is no year that's not an election year, even if it's just a special election that nobody really could plan for. So I do think that's really exciting. Do you think this has anything to do with people wanting change? Do you think it has anything to do with equity or diversity, or like what would you attribute kind of like the uptick in people saying, you know what, I think I'm going to go out for that? Because we've had a lot of first-time candidates on the show.
So I think it's that I know for myself, this last year that I've been running, I've been hearing from a lot of people, we need change. And not because of race, but they want to feel as if their voice matters in the courtroom, and people have been asking me, like, what are you going to do when you get on the bench? Because I've been talking about criminal justice reform because it's there. People are demanding it. People want to, they want it. They want to know, what are the judges going to do about it? Are the judges committed to really making changes in how they sentence, how they deal with people who have drug problems, how they deal with folks who are first-time offenders? And so, this change is coming from the groundswell. It really is.
What would you say too? I think about the area of Gwinnett, because Gwinnett is, I think, one of the most uniquely diverse counties as far as the major Atlanta metro counties are concerned. It's a huge Latino population, and I also kind of feel like, just in terms of raw numbers, I mean, Gwinnett is just a big county. So like, are the needs, or are they unique in Gwinnett? Are there specific and like special challenges in Gwinnett that may not be elsewhere?
Well, I think because of the diversity, there's more of a need for judges who have cultural competency, you know.
Yeah, what does that look like?
And so that looks like when someone comes into your courtroom, there's a story that another attorney told me that they were representing a gentleman that was testifying, and that person didn't make eye contact. And so later when the judge was making their ruling, the judge said, I didn't find you credible. You didn't look up the entire time, your body language, you know. And what that attorney told me later was that was a cultural thing, because for that person, looking someone in the eye is considered disrespectful.
Mm-hmm.
And so for someone sitting on the bench, while you may not recognize that that's that particular person's culture, because you may not have had exposure to that,
Sure.
but to base that as your reason for why you didn't find that person credible, just being aware that there could be something, maybe the person was autistic or what, it could be lots of reasons, but to base your decision that this person was not credible because they didn't make eye contact, that's a part of having some cultural competency.
That's true.
And, you know, another attorney was telling me that they were in a courtroom and a young man comes in wearing a Michael Vick jersey a few years ago. And the judge says, I can't believe you came in my courtroom with that jersey on. Do you really think that was a good idea, considering as to why you're coming to court? And the attorney was really offended by that, because they said, you know, that jersey was the best thing that client had to wear. And so just being aware that maybe what you would choose to wear is not what this person would choose to wear. As long as it's not obscene, there's no skin show, you know, as long as it's appropriate, someone's covered.
Sure, yeah.
You know, and that's all a part of cultural competency. Cultural being perhaps this person, that's the best that they had.
Yeah. So there's the socioeconomic
the socioeconomic piece to it as well. You know, and so when someone comes into the courtroom and the first thing they hear is, why are you wearing that? Can't believe you wore that. You're already feeling as if you've been knocked down a peg, like this person's not going to listen to me. Sure. You know, and that's what was explained to me that happened in that circumstance.
I think one of the things that I observed the most so I haven't spent as much time in Georgia courtrooms as I had a couple of years ago, but we were talking a little bit before the show about how I was working on some probation reform, and I spent a lot of time in a lot of counties' courtrooms, mostly watching Superior Court hearings as they related to like probation revocations or violation hearings. And I think some of the things I observed maybe the most frequently was there's this disconnect between what the average person expects or understands about the judicial system and what the attorneys and what the judicial actors expect an individual to know. I think there are things that seem so obvious and so clear for a person who, especially an attorney, and especially someone who understands criminal procedure and advocacy, that for an average person, I don't think is so obvious. And one of the biggest examples I can think of is so often when there is an individual, a defendant, in many of these cases, who is being discussed or who maybe a question is being presented to their counsel, and they'll speak and they'll interject or they will ask a question or be like, what? And how angry and frustrated that can make judges quite often. Yeah. And I think that there is this assumption a lot of times that person is intentionally or willfully undermining the procedure, creating dysfunction and just trying to maybe even just being obnoxious. Yeah. When I think unless you spend a lot of time in these places, which maybe some defendants had, maybe some defendants hadn't, I think most people grow up socialized that when they're being discussed, that they can speak. Mm-hmm. And so I also think that there's this huge divide, I think, between, again, like what the average person expects walking into those situations, especially at that level. I think most people are probably familiar with what it feels like to be in traffic court or, like the recorder's court. Most people have had a ticket. They've had that experience. But it's very, very different experience walking into Superior Court, from what I observed.
Well, and it's very intimidating when you think about the layout.
The buildings alone.
Yes.
Yeah.
But you think about the layout of the courtroom. The judge is sitting probably about 5 or 6 feet up higher than everybody else, right? So this person is actually lording over you. So it's a very intimidating, edifice when you walk into a courtroom, and you're made to stand when this person walks into the room.
Right.
So it's very intimidating, and I always would educate my clients about these are the things not to do, what not to do when you're in the courtroom.
What to expect.
What to expect. And I think they just get so caught up in the moment that all of that kind of goes out the door.
Yeah.
Because you tell them if you have something to say, because I usually give them a notepad or some paper, write it down, because I can't listen to what's going on and have you in my ear at the same time. Right. So write it down. But they get so caught up that they have to tell you. But I don't think it's intentional. They're caught up in the moment. Yeah. And they feel like whatever they have to say is so important that they have to tell you. Yeah. Right now.
And to be fair, it's a very quick process. That sounds strange to say because the legal system is not a fast machine. But for an individual, and like to think about a docket that may be 10 or 20 cases long, and sometimes for those individuals, this is a big thing. I mean, it's something they've been waiting for weeks or months. It's been pending. It could be gone. It could be done in 10 minutes. And it's so brief for it to be something that could be so life-changing for that individual. I think a lot of it has to do with there is all of that anticipation by that person. There are only so many pieces of the process that they're directly involved in. And it does kind of feel like, I don't know if I'm going to be back here. Like, this could be the last time I get to be here. Like, it's also I think, quite I don't want to say dramatic, but it's a big deal for that person. And I think there could be this sense that, again, in the way that you said it, intimidating being like the perfect word, that feeling that maybe I'm only one of 20 people. I'm only one of 20 people this person's going to see today. But, this person's name has been on my lips for the last, 6 months because I knew I was coming in this person's courtroom.
Yeah. Intimidating is the best way that I can think about it.
For sure. I mean, I think there's a level of grace that I appreciate you saying that just has to be there. I think cultural competency is important too. And then I also just think that grace, and there's some great judges who I know have that down package to really appreciate, and just respect that for that person. It is such a big deal, whatever the proceeding is, even whether it's divorce, I mean, whatever the case is.
But I think one of the worst feelings that I hear from clients is that, they felt as if they didn't get a chance to tell their side of the case. And I've seen it where the judge is impatient, doesn't want to hear what the client has to say, and it leaves that person feeling bitter about the process.
Sure. Yeah.
And so one of the things that I know when I'm sitting on that side of the bench is that I'm going to make every effort to ensure that all voices are heard in the courtroom, because I've heard too many times from clients, particularly ones who've represented themselves prior or had another attorney that they didn't have a great relationship with, is that they just didn't feel as if their voices were heard in that courtroom, or that their story was told.
Yeah, I think that's really, really important. And I also wanted to talk to you about the concept of fairness on the actor side, because I also think there's a different dynamic, at least it seems from an observer's perspective, between the prosecutor's relationship, or at least the prosecutor's role in a proceeding, and the defense attorney's or the defense counsel's role. And I'm always also very curious as a judge how the procedure how the procedure works, or how you ensure fairness for an example in a hearing where there is an accusation of any sort, like maybe it's very, very early on, and maybe even if the defendant is currently in custody. Mm-hmm. How do you as a judge ensure that there is fairness on behalf of maybe the person who you see pretty often, who works in your office or works in the district attorney's office, versus like a private attorney who maybe you don't see quite as often? How do you ensure that there's fairness and equity there?
Ensure that everyone gets their opportunity to tell their story, because the DA has their version of the facts, right? Mm-hmm. And then the defense counsel will have their version of the facts. And so there is the tendency, and I've seen it when I've gone to other jurisdictions that I don't practice in often, mm-hmm. and you're there in front of a judge that you're not familiar with, and you see other attorneys getting away with some, and when I say getting away, I mean,
you mean getting grace on something?
Yes, getting some grace on something, and then when I come up and I'm not familiar with that judge, the same mm-hmm. difference is not there. So I've seen it. There is some familiarity, which is why I always tell people that if they have a case in a certain county, I tell them, get a lawyer who mm-hmm. practices in that county. Yeah, I can go represent you in mm-hmm. South Georgia, or I can go represent you over in, Carrollton or something like that. I said, but I don't practice over there.
Right.
You need to get someone who knows those judges, who knows mm-hmm. what that judge will allow, what they won't allow. Because when you come into someone's courtroom and you're around them often, mm-hmm. there is the familiarity. And it's not that the judge favors that person, mm-hmm. but that attorney knows what that judge will allow, won't allow.
Right.
And so.
Sure.
Makes
sense. That makes perfect sense. And so as a judge, I feel like because you've been an attorney, you're incredibly cognizant of that as well.
Yes. So
I think the only other question I'd like to ask you too is, like, as we move from this to, I think, to your platform and to why you're running, and why, and how people can make sure that they're participating in that process, is what does a trajectory look like for a judge, especially, or for a circuit that is promoting change? Do you think that there is a certain amount of times or a certain amount of cycles at which change is necessary, or is it too hard to put a number on it? Because one of the questions that I have for a lot of actors is, it's like you implement systems mm-hmm. and you implement changes that are very important. And while we don't want the same person maybe in the same office in perpetuity, there's also the question of, like, well, once you start a program and you know that program really well, you know that staff really well, is change a disruption, I guess is what I'm asking. So do you think that a circuit is better served when there is a standing individual for a certain amount of time? Or do you think that a circuit is only really well served if there is, change enough to keep it fresh? Am I asking that clearly?
I understand the question. I think that's really the question for the voters, because the voters will tell you if they're ready for change.
That's true.
So, you may want to hold on to your seat because mm-hmm. you've been there for 20 years. Mm-hmm. If the voters say it's time, then it's time. But if you get another 4 more, then that's really up to the voters.
Really well put. That's really well put.
I, of course, would like to see change.
For sure. I think that's very true. And I think Gwinnett has shown that in other races over the last couple of years. So on to this race in particular, mm-hmm. Can you talk about when you've announced? Can you talk about the campaign, how it's been going, what you've been up to, who you've been talking to?
So I announced last year, March 2021, and I have been hitting the pavement ever since, showing up to Democratic events, Republican events, getting out there to churches, community organizations, and letting everyone know I'm a candidate, I'm running, I want your vote, I want to be a servant to the community. And just really this last year has been about letting people know that I'm running and why I'm running.
Has this been what you may have expected when you announced? Like, has it played out the way that you thought that it would, even with kind of COVID looming over? Has this been the experience that you were expecting as a first-time candidate?
I think I was a little naive.
Okay. That sounds like a realistic response.
Yeah.
I know it's tough. I've served on enough campaigns to know it's tough.
I really believe I was a little naive about how political the process of running for judges.
Everything
Yes.
is. Dog catcher is.
So, and I really did not expect that. Because a lot of what I hear is, when I go into some arenas, is, are you liberal or conservative? And they don't want to accept that this is a nonpartisan race, and my personal political opinions have no bearing on how I will rule as a judge. That's because true. I have to follow the law and work within the confines of the law. And that doesn't satisfy.
Yeah, that sounds about right.
And you know, and I can't answer their questions when they're asking me, what are you going to do about the Second Amendment? Well, sir, that's really a question for your legislator.
What can I do about the Second Amendment? Yeah.
I have no control over the Second Amendment. Now, if you're asking me how I would rule if a case came up regarding the Second Amendment, I can't tell you that.
Yeah.
Yeah.
No, I think that makes a lot of sense, but it's surprising. Well, I shouldn't say it's surprising. It's consistently the case that people really, really want to know about people's political opinions on an array of issues. Even if your office in particular is partisan, asking mayoral candidates if they're pro-life or not doesn't make any sense. In their jurisdiction, it makes no sense.
Particularly
but
when
comes up.
It comes up. And particularly when that person would have absolutely nothing to do with that issue.
At all. But it does. It happens. And people want to know more about, they want to know, do you pledge? Do you support the pledge? Do you support pledge in schools? Do you support prayer in schools? I mean, there's all these little ways of kind of getting around and asking those questions. I do have a question.
I had someone actually on my Facebook page ask me, could I define what a woman is? And another question that I had was, can I define what a woman is? Did I believe that there was evil in the world?
I may be out of the loop on that one, on what they're alluding to there. I think I'm out of the loop on that.
I had no clue.
It's got to be tied to something.
I'm sure that it was, because there were comments below that one that indicated that there was some discussion that was going on that I'm not familiar with. Yeah. But that's a question some people wanted to know.
I got to spend more time on social media to know what that dog whistle is. I do know that there's a way of riding the fence in which you take a picture at the Pride Festival and you post it, and you take a picture with the gun and the flag and you post it, and then everybody will be happy or not because they see the other picture. But no, I think there's a lot to be said about that. I do think, so to our earlier point, there is something to be said about buy-in. And there are ways in which I think, fairly enough, the legislature and the decisions that they make or don't make can be either like expedited and really supported by our system, or they can be there can be hesitancy, and there can be challenges around some of those issues. And so I think to that end, it's important to know that somebody has the energy to do the things that they may be asked to do, versus whether or not they may have resistance, to any of those things. I think that's maybe a fairer question as far as where a judge stands on certain issues. Because there's a lot of administrative work and a lot of legwork that goes into enacting some of these decisions. So how do you imagine approaching some sort of a change once you are in this position? Because you'll have a staff and you'll have a team, and there'll be a court clerk, but it'll also be you having to be responsible for carrying out a lot of that work. Yes. So how do you feel how do you see yourself working with a brand new set of folks and being somebody who has to carry these sorts of things out? Would that be something that would be challenging, but is it a challenge that you feel like you're very up for? I'm up for it. And I could work with anyone. Now the question is, will they work with me? Yeah, that's true. I could work with anyone. I mean, I've been an attorney for 27 years. Some of my co-counsel have not always been my most favorite people, but I can work on a case with you and smile and be gracious and be courteous and treat you with the utmost respect the entire time. So I can work with anyone.
you know.
That's an important piece. One of the big reforms that a lot of my colleagues are behind is what's been known colloquially as raise the age, because Georgia is one of a few places in which a 17-year-old can be referred to superior, which you know very, very well. That has not moved as quickly as a lot of folks have hoped that it's moved.
We thought I thought it was going to get some traction this last session.
Yeah, this is maybe the fourth or I can't remember how many years it's been that we've been chipping away at this. And there has been, again, like a lot of, to be fair, some of the most vocal opposition to this, actually the Sheriff's Department, our Sheriff's Association, have been very, very vocal about raise the age, about the administrative hassle they believe it's going to cause, and a little bit about their opinions about 17-year-olds. And like our, I want to say Norris, the president of the Georgia Sheriff's Association, has said in particular that there are some very big 17-year-olds out there, and that they've done some really bad things. So again, he's not a legislator, right? But he's somebody who has used his platform and used his position representing law enforcement to say that this isn't a reform that he supports. So do you think that there's something to be said about how you would approach this change if it was to happen, or how you could sit on the bench and maybe listening to somebody's case, listening to somebody's story, make a decision that does respect that person's age and that they're 17 years old, independent of the law?
And so in looking, well, if the legislature did pass the law that allowed someone 17 and under, those cases could go back to juvenile court. You know, if it was a felony,
that's right.
It could actually end up going back to juvenile court. And one of the things that I was talking about at the beginning is in juvenile court, they have resources for young people. Doesn't mean that person won't go to a detention center.
Sure.
Because depending upon the crime, they very well could end up in a detention center. And if the sentence is long enough, they could end up going into an adult facility after being into a youth detention center. So just because they change the age does not mean there won't be accountability. And I think that is some of the concern for folks who are against changing that age from 17 to 18, is that they fear that there won't be accountability for the young people. And I don't believe that is the intent behind raising the age to 18, because there still will be accountability. They still will have to go before a judge. They still will be sentenced. Difference would be they would be sentenced as a juvenile rather than as an adult. But there will be accountability and they would be sentenced. And so regardless of what the law is, 17 or 18, if that person is coming before me, I have to apply the law as it's written.
Yeah, it sounds like the push or the opposition is the idea that adults facilities will be tougher. And so they're equating tougher to better and saying that that's where 17-year-olds belong. So how do you feel about that idea that tougher is better, that tougher will lead to more rehabilitation, that tougher is a better deterrent? I mean, is there can you understand where that comes from?
I understand that. Studies haven't borne it, though. I understand the rationale, but the studies have not shown that because you give someone more time, it's not a deterrent for the next person. It's not.
That's true. Do you think that there is something to be said about victims' rights and even like the family or the recommendation from the prosecutor? Because I think that also the question is, or at least the argument as it goes back and forth, is that a judge is either on a side, that you're on a side, right? Like we have an adversarial legal system. So somebody does lose, if not everyone loses in a lot of these cases. But the idea that somebody does lose, does that mean then that the judge is choosing or allowing the potential victim's family to lose if they do not just, enforce that maximum sentence, like to the fullest extent of the law. Like that's a very common phrase. Does that mean that it's necessary that judges are tougher, that they lean tougher to show more respect to a victim or to a victim's family?
So each sentence,
I do believe there's gray area here, to be clear.
Yeah.
But I also feel like there's such a bilateral conversation going on.
Well, but each case in each sentence is different, because someone comes before you who has committed a first-time offense. They're not going to get the same sentence as someone who is a career criminal, per se, right? Or who has multiple offenses.
Sure.
And so then it's very reasonable that a judge would go to the max. Or if there's a heinous crime, go to the max. So it's really going to depend. And I think if any judge were to say that I'm going to always prosecute to the fullest extent of the, or not prosecute, but sentence to the fullest extent of the law, that would concern me. That would concern me.
Because it means that they're not, or because do you think it means they're not paying close enough attention, that they're just doing broad brushstrokes, and
that they have not, the sentence may not be commensurate with what the underlying facts are. Even though there's always a broad, so with some crimes, you have a range of sentencing options. And so if you're always saying, or if someone said, and I can't imagine that a judge would, but if someone's always saying, I'm going to prosecute, I'm going to go for the max in each sentence, that's not realistic, because you need to look at each case on a fact by fact basis on how you would rule. You know, because someone, depending upon the facts, may be very deserving of whatever the highest sentence for that crime would be.
Do you think some of it may come down to a question of like efficiency? So maybe this is another question that we can talk about with regard to your current race now, because I don't know where the backlog stands at the moment, but I do know at the height of COVID, they were talking about, especially for the major counties in Atlanta, that there may have been over a year's worth of cases in a backlog on top of what was already existing. So it's almost like adding an additional year of work with no extra time to do that work. How do you approach justice, which we know it's not an overnight process, but how do you even approach making sure that people are heard, as we've said, and that like cases get their due time, as we've said, without also making them delayed to the point where people feel like this is justice delayed? Like how do you even approach just from a work perspective?
So there are some efficient things that a county, a judicial system could do. For instance, Fulton County uses hearing officers in their family law cases. So the hearing officer would hear preliminary things. So if you file your divorce, there's a preliminary hearing or initial hearing to determine some initial things like some child custody while the divorce is pending. You can use a hearing officer to hear some of those things, to take that off of the Superior Court judge's case. And they could use magistrate judges for that. Gwinnett has a lot of part-time and full-time magistrate judges that they could use to hear parts and portions of a family law case. That would free up some of the docket for the Superior Court. And other things that could be done, if there are like evidentiary matters, that the disputes that the attorneys are wrangling over. Hearing officers could hear those sort of things. They could hear motions. Take those things off of the docket and let the magistrate court, who's sitting under that Superior Court judge, hear those things. And they could be running simultaneous courtrooms, right? Other things that could be done is when COVID happened, the courts pivoted very quickly to streaming the hearings. that could be, and some judges have now stopped doing that because, they weren't very crazy about it anyway.
Yeah.
So use video hearings for things like preliminary hearings in criminal cases. If we have something that we call Preemptory Calendar, pretty much where you're just coming into the court to tell the court, like, what's the status of a case that's been pending for several months? Where are we?
Gotcha.
So instead of an attorney having to drive to court, find parking, get to the courtroom, sit there, wait on a calendar for the case to be called.
Gotcha.
Those sort of things can still be done virtually. Instead of clients, and if it's a simple hearing, right? Like an uncontested hearing, instead of folks having to take the day off from work, let's continue to do those things by Zoom. Let's continue to do them by WebEx or whatever that format is. So folks don't have to take the day off from work, have to get babysitters, lose time. And attorneys could handle multiple hearings like that. So those are just a few things.
That definitely sounds good to me.
That could be used to help with the backlog, And we're not reinventing the wheel. Other
That's
counties
true.
are doing them.
That is true. That is very true. What would you say is the biggest differentiator between you and the sitting judge?
That I am committed to criminal justice reform, and I'm committed to making sure that every voice is heard in the courtroom.
Okay. Is there anything about past history, past experience that leads you to believe that that's not the case with Judge Hamill? Is there a poor handling that people should know about and can further research for themselves?
I would just say that I am committed.
Okay.
To hearing and respecting all voices
Sure.
in the courtroom.
Okay. That makes a lot of sense. What do you think that people should know about judicial races, specifically about the Superior Court, that they may not be looking into? Because I do think for a lot of people, they spend a lot of time just picking up on the name recognition cues as they're going in there. Maybe some people just vote down the ballot with partisan races, but with nonpartisan races, I think they end up either looking at the top of the slate or looking at the name that they see the most often. What should people know about the importance of this seat in particular and why it's so important to look into who the candidates are?
So it's important because Gwinnett has an opportunity to elect judges in May. For myself, I'm committed to being the change that I want to see. And if they don't come out to vote in May, you'll get more of the same of what you already had. And so if you're someone who's concerned about what happens in the courtroom or what you believe should happen in the courtroom, then come out and vote. Starting on Monday, May 2nd.
That's right. Early voting
starts May 2nd on Monday and runs through May 20th. And there will be Saturdays and Sundays. Check with your county to see if your county is doing Saturday and Sunday voting. And Election Day is May 24th. And we're not on the November ballot. So if you do not come out in May, you do not have a say in who your judges would be. And again, Gwinnett has 3 contested races for Superior Court.
That is remarkable.
With incumbent judges. That hardly ever happens. So, but if you want to have a voice, you have to come out and vote.
I love it. We believe in early voting. We want people to get out and vote early, as early as possible. May 2nd, Monday, May 2nd. That's when early voting starts. Tell people where they can find out more about you, what website they can go to, maybe another event that you're going to be speaking at, but how they can find out more about who you are.
So they can find out more about me by going to Karen Scott Greene. That's KarenScottGreene.com. You can follow me on all social media at vote 4K Greene, and Greene has an E at the end.
I like that. I like that. Very nice and simple. Well, thank you so much, Attorney
you.
Scott Greene. This has been wonderful. We're going to have another episode of the Leadership Blend. It will be virtual next Friday, so May 6th, at noon, as usual. Thank you so much, Candidate Greene. We appreciate this. We want everybody to vote early, vote Monday, May 2nd. Continue to look up our candidates, continue to stay active and to stay involved. And we'll see you the next time on the Leadership Blend.
Thank you.